page. This is the first document I ever got. When I first learned this stuff, this is the first thing I ever read. This is the first thing I ever read. So I want you to start, and I'm going to read this to you. The first time you were in court, okay, I'm going to read the last page. I'm on page, what page is this? It's 63 on the PDF numbering system, 63 out of 94. It says, the first time you're in court, the lawyer will read the lawyer letter into the record. The lawyer will almost always say he cannot or will not read the letter into the record. He will whine and imply that you are silly and maybe even stupid, but he will read the letter because the judge knows he has it and has been instructed to read it. He knows this because you've asked him to file it with the clerk in the file. If he does not have it in the clerk's file before the hearing, you can put it in there on your way into the hearing. Get a certified copy of it to show him when you sit down next to him at the defendant's table in the courtroom. Also be prepared to give him cues on what you want him to do. You might be prepared with cards with large font messages for him to read if he gets off track. Don't argue any facts. Enter the judge's oath into the evidence file. Read my letter into the record. Enter my bond into the evidence file. We're here for settlement and closure. Ask the judge to discharge the bond. There is no controversy. Do not call any witnesses. Do not cross-examine except regarding the notary certificate. Now, here's the next thing. I want y'all to listen to this because this is how it goes. This is why the question that he just said, you'll never see it in the record. That's one of their little demonic ass ways. That's how they got the system set up so nobody ever finds out any of this that I'm telling you about. So right here it says public defender. This is on page 59 of 94. If there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant. Remember rule number 1, the public and private can never be mixed. They can't do it and you can't do it. They don't ever mix them, so be careful you don't either. If the defendant has a public defender, this is good. When the prosecutor signs a complaint verifying it and his signature is notarized, he's taken on the liability that may follow in the event it is discovered the complaint is not valid. He is taking on a chance because at this point, he's the only attorney of record. He has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant until someone takes his place. And I want to tell y'all this. This is the most important part because when you get an attorney, before he puts in that notice of entry of appearance, he's going to come to you and talk to you in jail. He may file something like he may say, hey, look, I'm going to waive arraignment. Waiver of arraignment is a not guilty plea. I never understood. This is what I want y'all to ask yourself. Why do they always put in a not guilty plea for you and then 8 months later offer you a plea deal? The not guilty plea is to get the liability off of them. And if you look at the timestamps, when you get the docket sheet, you're going to see that they're going to file a notice of entry of appearance right after they're going to file, put in a not guilty plea for you. That shifts the liability from them over onto you. These are things, once you understand what I'm talking about, all this shit that they talking about right now, and I'm glad that you're bringing this up because you're just burying yourself because I'm gonna reveal everything to these people. That is how they hiding all of this. What we are saying, y'all hiding it. I don't understand what you can't understand in your small brain when you talk about, can you find it in the record? The reason I'm saying this is because they're hiding it. So the reason I'm teaching all this is to show people what to look for. You're hiding it. You're liars. You always resort to that, oh, well, you know, the courts have ruled against it. No, the courts rule against something procedurally, never substantively. They never go to the substantive issue of it. It's always dismissed on, oh, well, this is that sovereign citizen stuff. It's always something procedural because the people coming in the court don't understand procedure. Don't play no games. Don't play no games, man. I done read all of this stuff. You playing games and you a devil. And I'm calling you a devil to your fucking face. You a demon. Y'all demons. And y'all come on my channel. I see what y'all doing. That's why y'all over here fucking with me. I don't come on y'all's channel. I do not come on y'all's channel. I'm over here teaching the people what you got against me. I'm not following you. because I'm telling the people the truth. Let's continue. It says, when the prosecutor signs the complaint, verifying it, and his signature is notarized, he's taking on the liability that me following the event is discovered the complaint is not valid. I would have verified that in the statute. You go to here in Georgia, it's OCGA 17-11-4. Okay, and you can also find it in the federal, in the United States Code, that the prosecutor's name must be inscribed on all indictments. You will see a lot of indictments that aren't signed by a grand jury foreman.
Listen, you're a great guy, but you're not